Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Pereira. A 9-member bench of the Supreme Court today delivered a landmark judgment unanimously declaring the right to privacy a fundamental right under the Constitution. The Supreme Court has categorically held that the right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21 of the Constitution of India. The judgment represents a quantum leap in the evolution of legal jurisprudence pertaining to privacy in India. Privacy had emerged as a contentious issue while the apex court was hearing a batch of petitions challenging the centre's move to make Aadhaar mandatory for government schemes. On this edition of The Big Picture, we will analyze the implications of the Supreme Court judgment. Joining me on the program today are Aman, Sinha, Senior Advocate of the Supreme Court, Deepak, Advocate of the Delhi High Court, Prassana, Advocate of the Supreme Court, and Subhomoy, Bhattacharya, Consulting Editor of the Business Standard. Thank you to all my guests for joining me on this edition of The Big Picture. Prassana, I'd like to begin with you. What are the implications of this judgment?
There are going to be far-reaching implications of this judgment. But on the narrow question of whether there exists a right to privacy itself, right? So that's a right that we've cherished for more than 40 years in India. So this is, in fact, the government had not contested that there was a fundamental right to privacy in all these 40 years. It is only in this case that they chose to do so for reasons best known to them, as I've stated elsewhere in my other pieces. So in parallel cases such as the defamation case, criminal defamation case, and in other cases such as where disclosure of big loan defaulters was involved. So in fact, the government was arguing in the Supreme Court that privacy is a fundamental right. So it's only in this case that they chose to make that an issue. And we're all very relieved that a 9-judge bench of the Supreme Court, which is a rarity in our times.
It's a big deal. It's a big deal overruling an 8-bench judge's order.
Right. The 9-judge bench is a rarity, and even more of a rarity is the 9-judge bench speaking in one voice, unequivocally stating that privacy is a fundamental right, and the contest on that claim by the government being singularly defeated.
Sure. Deepak, I'd like to bring you to the picture now. The main ramification of this is the fact that right to privacy is now part of Article 21.
Yes.
And that says it all, doesn't it? I mean, right to privacy. The Supreme Court the Supreme Court has very clearly stated that right to privacy is going to be under Article 21, and the implications are going to be far-reaching, and the judgments to come in the near future are all going to be dependent on this.
Right. See, for me, I think, as I said in a previous episode on the same issue, that this is a right whose time has come, and perhaps this was long overdue. For me, what matters is not just the outcome and its implications for the future, but the reasoning adopted by the court and the multiple myths and perceptions that it has destroyed in the process. That privacy is an elitist sentiment, that poor people do not expect privacy. That has been categorically demolished, and if I'm not wrong, para 154 of the judgment. Then that privacy can be otherwise protected through a codified mechanism, through a statute. So why do you need something as sacrosanct as a constitutional right? Beautifully addressed to say that the reason that you elevate some of these rights to the status of a fundamental right is to take it outside the pale of legislative majority, so that no brutal majority is in a position to overturn that particular right, because a statutory right is effectively the creature of a particular statute, and therefore it can be curtailed by a statute. Whereas a fundamental right is there for all time to come. It forms part of the basic structure. It is therefore elevated to a different status altogether. So all these notions have been addressed, and as far as I'm concerned, 547 pages, 6 judgments in all within these 547 pages by a host of judges, I think is a brilliant read. It's a book in itself, and from a relevance and contemporaneous standpoint, the fact that privacy is an extremely important concern in a technology-intensive society, in a society which aims to be an information-based society.
At a time when we are talking about digital India, when you are pushing for digital India. Yes.
Exactly. That this is an essential concern. This is now a common concern. This is the Aam Aadmi's concern, has come out in a very crystal clear fashion. The only thing is, what are its implications from an individual standpoint, from a corporate standpoint, let's say from a commercial standpoint? These we'll see in the future.
Sure.
And I think the most awaited decision would be the decision in the Aadhaar case. Now, one would like to see what is the effect of this particular judgment on Aadhaar as it exists. To what extent would this judgment result in paring down Aadhaar as it exists as an ecosystem? Those are issues that need to be considered, because what is important is this judgment says that Article 21, the rights under it, are not to be judged only on the anvils of state action, but on the anvils of the effect of state action on individual freedom.
Sure.
Therefore, there has to be a very clear nexus between what you seek to do and its implications on people and the information that you seek from people. So I think it's a landmark judgment in multiple ways.
It is indeed a landmark judgment in multiple ways. Let me bring in Subhomoy and Bhattacharya now into the picture. You know, as far as the government is concerned, would you see this as a setback for the government, or is it not a setback at this point in time? Because the government has, in its own way, been batting for privacy. Only in this particular instance it has said no.
Sure. I mean, the Attorney General of the government went on in the court, and he argued that privacy is a common law and not a constitutional, and doesn't need a constitutional support. So definitely it is a setback for the government stated position, as Prassana is saying. And the larger issue out here is that, you know, once having made the judgment, a unanimous decision of this sort as the normative basis of one of the fundamental rights of the Constitution, it actually would be setting in motion something very important, like you would have to look at the Constitution itself, not just Aadhaar, but probably it is setting a standard on lots of laws which the Indian state will have to now take cognizance of going along. And that would mean redrafting quite a series of acts, because it is also mentioning, the judgment also brings in tangentially the right to property. Now, that was something that was a settled debate at one time. It has brought that in. It has brought in several other issues. So those issues would now need to be opened up. It is as significant as the Keshavanand Bharati case judgment, or so in terms of setting the basic structure of the Indian Constitution. So it is big. It is really big.
Sure. Aman Sinha, a good friend, joins me on the debate now. Aman, you know, as far as the law itself is concerned, unfortunately, we do not have a strong law that deals with privacy as such. Now that the Supreme Court has shown us the way, can we expect the legislators to bring out a strong privacy law?
Well, first of all, let me say that government has all along been of the view that right to privacy is indeed a part of fundamental rights and a integral part of Article 21. So therefore, it was very much enshrined there. This has been our consistent stand even on floor of the House when the Aadhaar Act was being introduced, and therefore it had constitutional protection. Now, as far as bringing in laws in order to have better legislative sanction, you would recall that Aadhaar itself had no legislative sanction earlier. In fact, one of the grounds for challenging the Aadhaar was the fact that there is no legislative sanction behind it. The government in 2016 has brought in a legislative sanction, and therefore that is a separate issue, and Supreme Court is examining that. But be as it may, no fundamental right is absolute. They are bound to be reasonable restrictions. In fact, this very judgment itself, Frank, it clearly stipulates and states that this is not an absolute right. This is subject to reasonable restrictions, just like any other fundamental right. So therefore, I do not see any ambiguity at all. In fact, we welcome this judgment. This has strengthened, the laws pertaining to, personal civil liberties, etc. So therefore we welcome this judgment, and this government has all along been of the view that right to privacy is an integral part of right to life, as enshrined under Article 21 of the Constitution.
Okay. Prassana, as far as the, let's take the debate forward and let's talk about Aadhaar now, because this whole issue started with a host of petitions coming out in the form of Aadhaar and whatnot. Now, but this particular judgment of the Supreme Court has nothing to do with Aadhaar. It doesn't say that Aadhaar should be kept out, but everything going forward will have to be taken up as far as this decision is concerned. So the decision on Aadhaar, or the judgment on Aadhaar, will be passed based on this.
That is true. But we need to understand the context in which this challenge arose. Supreme Court does not decide on matters that are purely academic. Supreme Court decides when there is a dispute. What was the dispute in question? Whether privacy was a fundamental right. So to that extent, what Mr. Sinha says now is not correct. In 2015, so this dispute was raised by the then Attorney General, Mr. Rothgi, and then the dispute travelled up to the 9-judge bench now, and then we have a judgment now. So now its implications on Aadhaar are going to be far-reaching. So one, there are a number of other detailed implications that it is going to have, for instance, on data convergence, whether or not you can allow online authentication for every purpose and whether you can store these authentication records, etc. Those are nitty-gritty implementation details. But the very idea of a general purpose identification database, in my reading, is not reconcilable with the judgment that's here. So if my reading of this judgment has to stand, Aadhaar will have to go.
Okay, Aadhaar will have to go is what you're saying. Okay, Aman Sinha wants to react to that. Yeah, go ahead.
No, first of all, let me say very clearly and categorically that government on floor of the House, while introducing the Aadhaar Act, Finance Minister Arun Jaitley had very clearly and categorically stated that right to privacy is a part of our fundamental rights as enshrined in Article 21. That is the official stand of the government on floor of the House. I do not know what my friend may be speaking about. Now, as far as, even thereafter, in arguments, Attorney General Mr. K.K. Venugopal had himself stated that this is a fundamental right, but just like any other fundamental right, this is subject to, reasonable restrictions being imposed on it. So there is no any ambiguity about it. The judgment also itself records that this is not a right which is an absolute right. In larger national interest for larger common good, these reasonable restrictions could be imposed by legislative enactment. So therefore, I do not see what is the controversy which is sought to be, raked up here. But I can just assure you, Frank, that all the large social welfare schemes which are running, whether it is Aadhaar or n number of other targeted social welfare schemes which are there, this judgment will not have any effect per se. You are right that as far as the Aadhaar card issue is concerned, it is pending before a separate bench, and maybe there, these arguments will be tested, and on touchstone of right to privacy, the Aadhaar Act may be tested. But that is a separate issue. As of now, it does not affect any of the social welfare schemes of the government. And in fact, it strengthens, and if it clearly stipulates that right to privacy is also an integral part of Article 21, we entirely welcome it.
Okay, fair enough. Sai Deepak, I'd like to bring you in, taking off from what Aman Sinha has just said about, how privacy and national security are always at loggerheads. Is that argument viable?
See, I want to get a few platitudes and banalities out of the way, because that needs to be explained very clearly. It is nobody's case that any fundamental right is absolute, and it has been nobody's case ever at all. Therefore, to say that fundamental rights are subject to reasonable restrictions is perhaps Constitution 101. So that's something that need not be reiterated. Point number two, if at all this was the position of any contesting party before the court, then I'm not sure what led to 547 pages of reasoning by the court, if this is the position. I'm not sure. Three, all of this, at least this litigation and this particular issue and this judgment is a consequence of the Aadhaar litigation in the first place. So that backdrop needs to be understood. What led to this reference in the first place? Obviously, there must have been a concern with respect to the imposition of Aadhaar or the application of Aadhaar on privacy, and then the rebuttal saying that this is not something that needs to be protected because you have a separate statute to protect it. And the court must have asked itself, do you need a statute to protect it, or is it a constitutional right? So that's the context. So let's not muddle that particular context. Two, see, as far as, let's say, the issue of Aadhaar is concerned, or let's say any other scheme of the government is concerned, we have to ask ourselves in one fundamental question. What is the basic purpose of Aadhaar? And that is a question that the court will now have to specifically put to the government in light of this particular decision. And to the best of my limited understanding of what Aadhaar is, I have not been able to fathom as to what is the actual intent or the objective behind it. Multiple people have multiple answers depending on the question that is being put to them or depending on the forum they are before. So these are issues that need to be addressed. And importantly, I also want to say this. The most important aspect of this judgment from a common man's standpoint is, considering that the government is let's say, encouraging schemes like Digital India and everybody has a mobile phone, the penetration of technology has made privacy a common man's concern at this point of time. It is no more the concern of somebody sitting in, let's say, in a wine tasting room or an air conditioned room. It doesn't make a difference at all. As long as you're the subject of any kind of technology that invades your privacy or has the potential to invade your privacy, then this question will need to be addressed. Two, every fundamental right could potentially be at loggerheads with national security if it is stretched beyond the point, which is precisely why.
So where do you draw the line?
No, that line has to be drawn in the circumstances of each case, in the context of each case, and I have to give a lawyer's answer here because that is a very subjective landmine. It's a subjective discussion, and which is precisely why you need judicially trained minds to apply their minds to this question. So these questions are never answered in binaries, zeros and ones in black and white. This is a question that needs to be answered based on the issue that is escalated to the court. And as Prassana rightly mentioned, unfortunately or fortunately, courts are not in the business of doling out opinions without an issue being escalated to them. So each question will have to be addressed depending on the case. So multiple aspects of multiple limitations with respect to privacy will only come when those matters reach the court.
Okay, fair enough. That's a very valid explanation, and I take that argument that you put forth. But Subhomoy Bhattacharya, as far as the people's aspirations are concerned, do you believe that those aspirations have been met by the Supreme Court's judgment today?
There are two aspirations. I mean, one is obviously the aspiration as there's a lot of people who have fought on the Aadhaar case. The other is the aspiration of the people coming up who want a clean social benefits to be delivered. I'm not very sure whether the Aadhaar architecture has to go, because what has happened is that it has gone into lots of issues where its use is questionable. But what does Aadhaar do? The biometric identifier simply answers the question of whether the person whose number is being fed in is that same person. For instance, if a person's biometric, for instance, if it's asked to the Aadhaar base that give me the biometric of the person, those won't come out. It will simply answer at every stage. Aadhaar just answers the question of yes or no, whether this number matches the name or the biometric that is being fed in. That's it. If that is the case, and if that is the way it is used for identifying social service schemes of the government, I see no reason why that shouldn't be applicable. It'll also, the problem comes in when this sort of a scheme starts being used as a general purpose identifier, which Prassana said, into things like, for instance, flight booking or rail booking, commercial applications, where there are other ways in which the agencies jolly well could do their work.
Sure.
But so Aadhaar per se, the reasoning and the biometric identifier is just used for that. Now the other issue that is being raised, that Aadhaar could be stolen, is a technological issue. That has got nothing to do with the fact that whether Aadhaar base is right or wrong. So that is a technological issue which has to be handled as a technological
So in a
thing.
nutshell, the positives outweigh the negatives, and that's why it has to stay, is what you're suggesting.
Yeah. In fact, what the Supreme Court did was basically took the issue onto the question of privacy.
Sure.
Because that was the first principle on which it decided.
Yeah, Prassana, I saw you shaking your head in disagreement.
No, there was one factual issue that I wanted to point out. In fact, in the earlier regime, during the NIDAI bill, it was clearly mentioned that it could only give an yes or no answer. So under the current act, it is no longer the case. In fact, we have the eKYC mechanism, where in fact once you feed in the number and your biometric, the entire data in the Aadhaar database of your of the individuals is shown. That is how we see. I mean, a lot of people actually experienced that when the Reliance Geo revolution took place. Right? The reason why it was able to actually get in 300 million customers or whatever in the short period was because of eKYC.
No, that's exactly the point. This is commercial use, which is exactly what Aadhaar shouldn't be.
Sure.
But when you're using it for an identifier for a person, whether the person is entitled to a benefit on a particular scheme or not, then that's a different thing altogether.
Okay. Aman, Sinha, are you worried or concerned at some point in time that the judgment is going to further empower the hands of the citizen against the state?
No, not the least. And in fact, Frank, I feel the difficulty is that, there are a large number of people who comment without reading the judgment, and some homilies were given that how a Supreme Court judgment is written. But if somebody would have cared to see the conclusions, that they have themselves gone on to mention that this is not a right which is, an absolute right, reasonable restrictions could be imposed in interest of national security, etc. They have laid down all this in their conclusion. But I do not wish to get into all that. But why should state be, if the hands of our citizens are strengthened, the state should be more than happy. And the Supreme Court also has said that, this is a balance. This is not some confrontation or something. This is a delicate balance which has to be struck, and therefore, if there are any restrictions which are imposed, they are tested in judicial domain also on, test of reasonableness, or on the fact that, they should not be, ultra vires or discriminatory or in contravention to Part 3 of the Constitution. So whichever, reasonable restrictions that are imposed, if at all they are imposed, then, it will be put to judicial scrutiny. Since the government stand has been acknowledged and appreciated, I do not know where from, people sitting here on the panel are making such sweeping blanket judgments, when I have said that on floor of the House while introducing Finance Minister, that is the official stand of the government, he had argued this, that this is a part of Article 21. This is very much an integral part of right to life. Right. And if somebody starts, saying something else, I do not even wish to comment on it. Apart from that, what Attorney General Mr. K.K. Venugopal also argued was the fact that, yes, this is indeed a right, and like any other right, it can be, regulated, and reasonable restrictions could be imposed. So I do not see what is the point which is being argued, or they are trying to harp here.
I think that's the point that you made earlier.
But all I can say is that as far as all the social welfare schemes of government are concerned,
sure,
there was a targeted delivery. The wastages, slippages, and the other lacunas and voids which were there, they were filled up due to this scheme, etc.
Sure.
And therefore, I feel that the Supreme Court, although it is going to examine the validity of Aadhaar, but I think it has got enough legislative and other administrative safeguards behind it, so as to stand judicial scrutiny before Supreme.
Fair enough. I'm quickly running out of time. So yes, Sai, Deepak, no names taken, but reference was indeed made. So I'm going to let you respond to that. Yeah.
So before I lose an opportunity, first of all, I wish to congratulate everyone who's been a part of this decision and who's fought for right to privacy. That's point number one. Two, the issue before the Supreme Court was not whether the right to privacy is absolute and whether or not it needs to have any restrictions. The issue before the Supreme Court was whether the right to privacy is fundamental. So whether or not its absolute and reasonable restrictions apply is a question that needs to be answered only after the issue of its fundamentality is addressed. Therefore, the term of reference from the Aadhaar case to this particular case and to the 9-judge bench was whether fundamental right is a fundamental, or rather privacy is a fundamental right. So to say that the Supreme Court has finally recognized that no, it's not absolute, the court was never on the question of whether or not a fundamental right is absolute or whether the right to privacy is absolute. Whether the right to privacy is fundamental or not. And which is why to now say that no fundamental right can ever be absolute is to basically say that this is what the judgment was all about, when it was not. The question before the court was whether the right to privacy forms part of fundamental rights under Article 21. Not since it forms a part of fundamental rights, is it absolute or not?
Sure.
So let's set the record straight on that particular front. I don't wish to put anyone who's representing the government in a spot, but let's not actually muddle facts on what are the terms of reference before the court as far as this judgment is concerned. This is the fact.
Fair enough. And we'll end on a light note and on a happy note. Prasanna, as far as this particular case itself is concerned, a 92-year-old retired Justice Puttaswamy is going to be sitting somewhere in his house in Karnataka with a big smile on his face and really a pat on his back for what he's done.
That is true. And along with Justice Puttaswamy, who went to court in 2012 as the first person, there were also 20 other petitioners. Aruna Roy and Nikhil, they are also petitioners. Beswada Wilson, and we have also 3 ex-army men. Right? So we had Colonel Matthew Thomas, Sudhir Vambatkere, and also Major General Sudhir Jathar. And then we had Anupam Saraf, Vikram Krishna. So there were at least a dozen or so petitioners that have come to court, and big hats off to them, right? That they have pursued this cause. And it is a momentous day in the history of Indian Constitution. So the last time a 9-judge bench spoke in one voice unanimously in holding rights to be inherent in all human beings, inalienable, was in I.R. Coelho 10 years ago, and I'm happy that that position has been reiterated in equally unequivocal terms.
Okay, on that note, then we'll have to call it a wrap on this edition of The Big Picture. I'd like to thank Aman, Sinha, Deepak, Prassana S and Subhomoy Bhattacharya for joining me on the program and putting things into perspective for us. That's all the time we have today. See you again next time.